From St. Johnsburg.
I fixed it.
They
It's
refused-
What you do?
fine.
But what are
We
they?
are not- we are
We're not talking
Okay,
about
ready?
that.
Check. Thank you, Jesse. We are
Like,
live,
the
the
actual-
Senate Finance, and we have been having some technical difficulties, but we are out.
I asked her every couple.
Okay, we are live and we are got 10 whole minutes to make up. So we're gonna start with an act relating to the Uniform Commercial Code, H 206. We've got Rick and Carl Litzman, and I don't know how this works for either one of you.
We have a dog and pony show.
Okay, that's all I need to know. It's your,
I'm the dog.
okay. So I love UCC bills because it's up or down. There's no amendments allowed.
Rick Sagal, Office of Legislative Counsel. Good afternoon, everybody. So H 206, as the chair indicated, is a bill that amends the Uniform Commercial Code. I'm joining Zoom here. Give me 1 second. And just a little bit of background. Vermont does have several of these kind of uniform model codes. It's adopted over the years. The UCC, I believe, is the oldest one. It's been around since the 1940s, 50s. And the purpose of the UCC, and I'll maybe still in Carl's spotlight here, he's going to give you a much better education than I can. The purpose of the UCC is to facilitate commercial transactions. It's so a business in Vermont that does a deal with someone in California has the same guardrails that it has with someone in Texas, someone in Connecticut. It's the same laws that affect these commercial transactions. And the goal is to make these as simple as possible. You want businesses to be confident that a certain thing they're doing is going to be treated the same in all 50 states. So we have the UCC, and it's currently in Title 9A. Title 9A is just entirely the UCC. It is a model law that has been adopted by all 50 states. What you're looking at here is the 2022 amendments. So the people that I did not make these amendments, I'm not that smart. I am presenting them to you, but the UCC is developed by, my fault for having a big amender here. The UCC is developed by the Uniform Law Commission and the American Law Institute. And these groups get together every so often to hear testimony from lawyers, judges, determine businesses, what needs to be updated in the next round of amendments. And again, these are the 2022 amendments. Carl Litzman will talk about the details about, why these amendments are needed. But I believe 23 states or so have fully enacted the amendments from 2022. So we're right in the middle. Vermont is as far as taking these up. And another 10 or 15 states are debating them this legislative session, like Vermont is. So the biggest thing that these amendments do is addressing electronic transactions, cryptocurrency, non-fungible tokens, NFTs. You may have heard of those before. So currently, the UCC is kind of silent as to these arrangements. And there's a desire that people are using these NFTs, using these electronic versions of money as security interests. And it's important that the UCC recognizes these things are worth something and that they can be used to facilitate these commercial transactions. So it's 124 pages. Would you like me to read it word by word for everybody?
If you don't mind.
We're in the crawl.
Yes. I do want to make clear again that this is, like the chair said, the whole purpose is to keep it the same, state to state. And there are maybe only a couple of times where the Vermont version differed. The effective date is going to be specific to what Vermont is doing. There's a section at the very end that we added on the House side, section 11A, because Mr. Litzman here requested it. And in these green books, if you open up to 9A, you will see that the biggest part of this green book is not the actual law, it's the comments. Because if you start reading this stuff, and I'll show you an example. This is Title IX, which is secure transactions, or Article 9, secure transactions, talking about a secured party who they owe a duty to. And you can read the language there. This is new language. Almost every substantive portion of the UCC is going to have a comment, and it's going to explain the reason why they did this. Either it's to clarify something, either it's to give guidance to lawyers, to businesses who are interacting with the UCC. So we wanted to make sure that the comments are included in the green books.
And the comments are made by, there's a UCC board.
It's the ULC, the Uniform Law Commission, and the ALI, and they come together and they submit recommendations for.
And Mr.
Yes.
Listman is our longtime representative on that.
One of your,
What,
yes.
I've always been there since I've been here, and
Yes.
long time.
So, the last time we had, major amendments, I believe was 2011 to the UCC. And, there's been amendments here and there, 2015, I believe, 2019, but this 2022 is pretty substantial. And that's why you have a 124-page bill. Be glad to answer questions about anything specific, but again, I think Carl Listman will be a better way to get those questions answered for you.
I do want, so just so I understand, it's something we can't amend in the details, and it's either a yes vote or a no vote, and what happens if we don't put it into our statutes?
It's a good question. So you can always differ, and we have in the past, not with the UCC, but we have occasionally taken model language and tweaked it a little bit, but it's generally not preferred by anybody. It's again, the purpose of this is to ensure similar treatment, no matter where you do business.
Right.
So if you all decided to change something, for whatever reason it would be, right? If you just think the language isn't clear, or if you think something should be worded a certain way, we probably want to hear from somebody with the UCC to talk about what that would mean for implementation, how that might make things complicated. Because this language has been vetted by hundreds of people. That
And if we just don't do it all together, what are the implications of that?
sorry, and this has been put forward for a few years, 2022. So Vermont has not had this. And with these amendments, this is mostly including these electronic records that have not been specifically recognized in the UCC. I can't say it's stopped things from happening in Vermont that otherwise would be happening if you have this, but, and also let me take a step back. Usually two businesses have a contract, right? And they have terms in the contract. The contract's going to rule over the UCC. The UCC is in place if there's not a contract, or if something happens but the contract didn't anticipate. So then you have the UCC to take over. So if Vermont did not do this, or if you waited till next year, we would be further behind. Other states have already done this. And again, it's not going to stop commerce. These are intended to facilitate commerce, and especially these new electronic assets that are relevant.
Okay, any other questions?
And Carl will correct all the things I said that were not
Okay.
correct.
Chair, ladies and gentlemen, my name is Carl Listman. I'm a lawyer, live in Charlotte. I've been a uniform law commissioner for quite some time. Probably longer than some of the people sitting at this table have been. I started my presentation with the House Committee by asking whether you could name all of the governors over the last 50 years in the right order, and bonus points if you can get the right years. And the reason I started with that, other than to break the ice a little bit, was because I was appointed by Tom Salmon 50 years ago to be a Uniform Law Commissioner, which is a long time. And I've had the privilege of coming to this committee a number of times with a bunch of our uniform laws, including, as Senator Cummings noted, the last time we did the major rewrite of the commercial code. This is, you've got the green books there. This law, the commercial code, occupies 2 volumes. We don't have another law in Vermont that occupies 2 volumes. Even our tax law doesn't sprawl more than a big fat volume. The reason that it's so big is because of the subject matter that it covers. It's called the commercial code for a good reason. It covers all kinds of commercial transactions. Just to remind you that every state in the United States has the commercial code in the form that we have it today in Vermont, or will have it hopefully next year in Vermont, if this bill goes through. An update on the numbers: 25 states have already approved the 2022 amendments. It's pending in 17 legislatures now. Hopefully those will all become enactments before the end of the year. I won't bore you with what the commercial code includes, but it's important, I think, for you to have a general understanding. Currently, there are Articles 1 through 9, with a couple of A's thrown in on top. Article 1 are general provisions and definitions. Article 2, one of the 2 most important articles of the code, deal with the sale of personal property. Whether it's IBM selling computers, or me selling a used lawnmower, or a grocery store selling produce, doesn't matter. It's sale of goods covered by the commercial code. And it covers the whole gamut of what that means. You have to have a contract. What are the required terms for a contract to be binding? How do you measure performance? What happens if somebody breaches? What are the consequences of breach? What are your remedies? All of that is rolled up into Article 2 of the commercial code. What you could do by sale in many transactions, you can do by lease. In other transactions with the same practical consequence. So Article 2A of the commercial code covers leases of personal property. It sets out all the same types of rules as for sales. Article 3 is commercial paper. What is commercial paper? Checks, notes, indentures, teller's checks, traveler's checks, the kinds of, important word here, paper that we use as a substitute for money. When I say money, I'm going to go back to money too. Article 4 is bank deposits and collections. I'm not going to get into that. It overlays with federal law so that when I write a check to you, my check on my bank ultimately gets deposited in your account at your bank. How does that happen? And how does your bank know that it should accept my check? And what rules are there for your bank to say no? Or my bank to refuse to even allow me to give you the money or to give you the check? Article 5 are letters of credit, very much used in commercial transactions, not so much in personal transactions. Back in the day, a letter of credit was about the only way even before they started using carrier pigeons to transmit information. To give you the comfort that when I say I will buy 500 bushels of wheat from you, I'm in Croatia, and you're in France. How do you know that I'm good for it? Letter of credit drawn on an institution that you or your institution will recognize and be willing to trust. Then there's warehouse receipts, bills of lading. That's Article 7. Unless you are getting your furniture moved from one point to another, or you use these self-storage places, you will never know about Article 7. But if you do either of those two things, you care a lot about
Bills of what?
bills of lading, Lading,
Bills of leading,
lading, L-A.
leading. And what is 6?
6 is bulk sales and we repealed it.
So 6 doesn't exist.
6 does not exist
Okay.
almost everywhere in the country. Article 8 are stocks and bonds, investment securities. I'll talk a little bit more about that in a moment as well. And Article 9 are secured transactions, and that's really the prime driver of the 2022 amendments. We added an Article 4A on funds, transfers, electronic money wiring. I meant to look this up after I spoke to the House Committee. If my memory is correct, $17 trillion of money passes by electronic wire every day in this country. That's a lot of money. 17 trillion. That may be low.
One day,
One day.
one country.
Big country, but one country.
Okay, I just want to make sure I got this all written down right. Article 3 is commercial paper. Okay. And,
Article 4 is various commercial
okay, and then what is 8?
investment securities.
Okay. I'm getting ready for the test you're gonna give us. I'm the only one that's gonna pass it.
I hadn't even announced the text. How do you are a
I
studious
am a
person?
very good student.
So the reason that we have the 22 amendments, the 2022 amendments, is because primarily the subject matter of the 22 amendments didn't exist when the commercial code was written, or when we updated it broadly in 2015. And that has to deal with electronic cars. This committee heard some years ago, the Uniform Electronic Transactions Act, which is the law that enables us to do business on the internet and to be bound by our contractual commitments that we make on the internet. It validates electronic transactions. And that's pretty important because until there was a law to serve as a foundation for electronic transactions, people were reluctant to do business electronically. But now everybody does business electronically, and that's a good thing. One of the things that electronic transactions allow you to do is to do business with somebody that you can't see, who you never knew, who you will never know. And interestingly, vice versa. They don't know you, they'll never see you. But if you've got something that they want to buy and you want to sell, you can do that contractually under Article 2 under the commercial code. That's pretty easy. And most of the time, you and I do these electronic transactions. The payment method is a credit card or PayPal or some substitute for that. And it's payment up front and the transaction is consummated. Boom. But what if I'm selling and you're buying and you don't have $12 million to pay me for what it is that you want to buy from me? And maybe you want to borrow from your bank, or maybe you want to borrow from me, the seller, in order to consummate the transaction. You can do that right now in the real world today. You can go to a bank and the lender will say, $12 million, chicken feed here. Oh, here's 12 million. Unlikely. More likely, the banker is going to ask you for your creditworthiness and what collateral you might have. And you might put up your house as collateral. You might put up your business assets. In the old days, they put up their children. You shouldn't do that anymore. Do that. But
Jerome's like,
Wait a minute, asset or liability.
Capitalize your kids.
I have over the years thought about using my children's collateral, hoping to default, but I'm not going to.
We all have those days.
So let's assume that I'm selling you something that's durable. So let's use computers. Anything will work. This example. If you're coming to me, playing multiple rules here. So if you're coming to me as the buyer of $12 million worth of computer parts, and you're the lender, you're going to ask me, well, where are the computer parts? Where will they be? And then ask me this, how am I going to get my hands on the computer parts if my borrower defaults? Well, one way to do that is to have physical possession of the computer parts. That's good for the bank, but it makes it very difficult for me to put the computer parts together into a computer. I'm going to want to have the computer parts so I can assemble them and sell them. The bank is going to say, geez, how do I protect myself if I don't have the parts physically? Maybe what I can do is give notice to the whole wide world that those computer parts are subject to my mortgage. What we do with real estate with houses, buy a house, you borrow from the bank pays your seller the balance of purchase price. You sign enough, and the bank gets from you a mortgage, which we record in the land records where you live. So the next person who says, I want to buy your house, you say, fine, give me $100 for my house. That should be a signal to somebody, but more likely than not, they'll go and they'll check the records because they know when it comes to real estate, you check the land records, find out whether the person who says they own the property actually owns it, find out what problems with title encumbrances or interest there might be that affect the property, that might affect your use, with your ownership. And after you do all of that checking, you then go back and say, I'll buy your house, give me a deed, mortgage recorded. The personal property, it's very different because all pieces of real estate are unique. There are no two identical pieces of real estate. Or there are sure lots of identical ball bearings or ballpoint pens or computer parts or whatever it may be. So to bring this back to where I was, how do you, the seller who's financing the purchase, or you, the lender who's financing the purchase, protect yourself by getting some collateral? The way we do it till now on personal property is one of three ways. One way is for the person who's making the loan or getting the financing to take possession. Possession trumps everything. Second way to do it is to file something like a mortgage. Where do you file it? You file it with the Secretary of State. Which Secretary of State? Secretary of State in which the borrower lives or is formed. Delaware. That isn't. If I want to know whether or not there's a mortgage on the $12 million worth of computer parts that you bought with money that he lent you, all I have to know is where your organization is formed, and I go online, click, click, click. I give it the Secretary of State. It's here, and I can see a whole list of who's got a mortgage on what of your personal property. And that's true of stuff that we do as individuals as well. It's not just businesses. You buy a lawnmower and you finance it with John Deere or a Toro or wherever it is. You're on the record with the Secretary of State's office. So possession is best. Filing is good. What do you do, which is why I'm here today, what do you do when what you want to take as collateral doesn't have any physical attributes at all? I have in my pocket $12 million worth of Bitcoin. See? At some level, it's like the emperor's new clothes. You can't see it, you can't touch it, you can't smell it, all of that stuff. But people are doing business now electronically with, on my term, not the code's term, substitutes for money. Bitcoin, we call it money, but most people will call it money. It is money. It's a substitute for value. Historically, the value that we measure by is money issued by a government. We now call that fiat, F-I-A-T money. It's government sovereign sponsored money. In this country, it was silver certificates. You could always take your dollar bill if you could find out where to go, and they would give it the equivalent value in silver. And before that, it was gold. I'm not crucifying the Elvis cross of gold for those of you who remember your history. But now we have non-government sponsors of, my words again, the equivalent of money. So you've got a couple of issues here. Issue one is, how do you ensure the transferability of the money? How do you ensure that the transferee gets the equivalent value of what the transferor claims it was worth? How do you take a mortgage on it if they're lending against it? And then layer the level of complexity that now you're using electronic money to buy electronic goods. And you're financing part of the price of the electronic goods. And that's what the 2022 amendments deal with. But before we get the nitty-gritty, which I know you're waiting for, let me tell you about two other broad areas that the code amendments do this time around. One has to do with sale of goods and the provision of services. It's what we call, the courts have called for a long time, hybrid transactions. If I go to the store and I buy a lawnmower, sit-down lawnmower, and I get a service contract for that sit-down lawnmower, and later on there's an issue. The carburetor breaks and the store doesn't send the repairman like they told me that they would. And we end up in court. First question that a judge is going to ask in every lawsuit of any stripe whatsoever is, what is the law? What law governs this transaction? Well, for a long time, courts have struggled with, what law do I apply to a hybrid transaction? Do I apply Article 2 of the Commercial Code, which deals with how you form a contract, the sale and purchase of goods? What do you do about performance and breach and remedies? Do I apply those breach and remedies rules to the failure of the dealership to show up and repair the lawnmower, even though that's a service which is outside the scope of a commercial good? So ultimately, courts have struggled and they came up with a good solution, which we now codify in the 2022 amendments, which is to say that let's call these hybrid transactions and let's figure out which of the sides of the transaction predominate. And the one that predominates, the court shall apply. That'll work out very well in most transactions, in most disputes. I'm going to give a different example. Suppose it's time to replace the shingles on your roof. You hire a roofer. You're already ahead of it because the roofer's going to supply the shingles. And more likely than not, the cost of the shingles are more than the cost of the installation. But if there's a problem either with the shingles or with the installation, the judge who's going to hear this dispute is going to decide whether it's the commercial code rules or general contract law for the provision of services. I would say it's pretty clear to me that the shingles are the predominant part of the transaction. I didn't hire you to put up shingles without wanting you to put shingles up. So commercial. But suppose I'm a medical doctor and you come to me and you've got a problem. And I listen to you and I listen to your heart, all those things. And I say, here, the solution is take these 2 pills. And I send you a bill. Services rendered, $500. Supplies, $2. Suppose there's something wrong with the pill and you get really sick. Now you sue the doctor. What law is going to govern? Well, the bulk of the transaction was the services part. Doctor diagnosed me to diagnosis. I think every judge in the world would say we're going to decide what the rules are with respect to the pills under the commercial code. So solution 1 is codify the way judges have been dealing with hybrid transactions. Number 2 is definitions and terms. Again, I'm jumping around and I apologize, but where I have to start here with is the word record. Not to be confused with the word record. The difference. Up until 2015, the commercial code referred to writings. Contract should be in writing. Parties to a contract shall sign the writing. 2015, we said, wait a minute. We're doing more and more electronic transactions. We can't say writing anymore. We have to find another word that encompasses both something that's on paper, parchment or marble, and something that's not physical. So we came up with the word record. So now throughout 2015, throughout the code, we changed in writing to record. The definition of record, I love this. Information that is inscribed on a tangible medium or that is stored in an electronic or other medium and is retrievable in perceivable form. English much we often speak, but it works. And it's important because it's part of the foundation for the 2022 amendments. The UCC also defines money. The UCC definition of money has always been and continues to be under the new amendments, a definition for the purposes of the UCC only. Definition of money in the UCC doesn't tell you what money means in other contexts. That's important because some people have thought that the commercial code is trying to take over and require the government of the United States to use only electronic money and get rid of paper money. Not so. Our definition is just for UCC purposes. More than another definition. Because when I was growing up, people had clocks and wristwatches. And you could look at the clock, you could look at your wristwatch, pocket watch, and that was the only kind of time there was. Until someday somebody came up with a digital clock and a digital watch. And now you had to come up with a word to describe the one that hangs on the wall and has hands that go around. We came up with the word analog. So now we have digital watches and analog watches, digital clocks and analog watches. Now we have to do the same thing with money, because now we have money that is tangible and money that is intangible. So now we have electronic money, which we're using as a defined term. And I'm getting to the meat of it now. There's a third change in this area of definitions and terms that have nothing to do, has everything to do and nothing to do with what we're talking about. And that is the word conspicuous. You've all dealt with bills over your time here in the legislature where you want to be sure that somebody really understands what it is. You shall post a warning. It shall be conspicuous. It will be 12-point type. It'll be in red ink. Whatever. With electronic stuff, conspicuous doesn't quite fit with 16-point font. It can be conspicuous because it bounces. It can be conspicuous because it zooms in and zooms out. So rather than using the fine term that we've had for years in the code about font size, appearance, color, and that, now it says that conspicuous means what the totality of the circumstances require.
Would this be a group quiz and can I be with Senator Hardy?
This would be open book. That would be even worse. I always hated open books. You meant you had to know more than you knew. So you got a bill that's on 124 pages, it's a long book. And a lot of it is there to change the rules to be sure that when you're dealing with something in electronic commerce, the result is as close as it can be to dealing with physical commerce. So you go buy a house, you borrow from the bank, you sign a note to the bank records a mortgage. You go to buy computer parts, Bank says, give me a security interest in the computer parts, I'll file a financing statement with the Secretary of State. Same thing with electronic transactions, except that there's part of the electronic transaction where you can't physically take possession of something that doesn't physically exist. And you can file a financing statement with the Secretary of State. But there's a way to even get to a higher priority than that, and that is to get control of the electronic record. So the 2022 amendments create a set of rules that fit electronic transactions into the code without having to tear up the whole code. Let me give you an example, and that'll be pretty much done. Suppose you have an electronic wallet. Suppose you have $10,000 worth of Bitcoin in that electronic wallet. Suppose under the terms of the electronic wallet, you are the only person who can get into the wallet. And suppose you do get into the wallet and you say to me, I would like to pay you for what I'm buying from you in Bitcoin. I am the only one who can get into the wallet. I am the only one who has the authority to transfer the Bitcoin from me to you. And I am assuring you that there is nobody who's got a claim against my Bitcoin that would interfere with your ability to have it once I move it over to you. That's what the 2022 amendments allow to happen. It's a little bit like three-dimensional chess, because when the rules for secure transactions and sales of goods were written, electronic commerce didn't exist. So a lot of the changes in the bill are in Article 9, secure transactions. Some are in Article 2, sale of personal property. And there's now an Article 12, which sort of ties all of this together with the electronic transactions. And those of you who've been paying attention, and I know it's all of you, I told you that we had Articles 1, 2, 2A, 3, 4, 5, 6, 7, 4A, 8, and 9. And you're saying, well, wait a minute, if it stops at 9, how did it get to 12?
It's gonna have that, by the way.
Senator Hardy said.
Got to 12 because there were Articles 10 and 11. They were both transition provisions. And they've all since disappeared because transition came and went. One of the great advances, Senator, you asked a question earlier about what ifs. Let me address those here. What if we don't adopt these amendments in Vermont? The world won't end. But lots of people may not want to do business with businesses and individuals in Vermont on an electronic basis, because the rules that are set forth in the 2022 amendments won't be there to set the foundation for our transaction. Now, I can't tell you categorically that if we don't adopt these, you or I as individuals will ever notice it. But the businesses in Vermont will notice it, and the banks in Vermont will notice it. And maybe more importantly, the banks outside of Vermont will notice it if you not want to do business with Vermont businesses. Second,
Sorry, want to finish your presentation?
second question was, what if we change something? And it's the same answer. Depends on what the change is. So much of this is so esoteric. I was at lunch 2 weeks ago with a bunch of people, including a woman lawyer from Philadelphia. He told me in a moment of breach of confidence how much her billing rate was. I spoke to a lawyer from Texas last week, and he told me, I told him what I was about to tell you, and he told me, oh, So the woman in Philadelphia charges $1,900 an hour for her legal services. The guy in Texas charges $2,200 an hour for his legal services. Lawyers in Vermont might, really high-end transaction might charge in the high $600 or $700 or $800 an hour. Most lawyers in Vermont probably charge a whole lot less. The lawyers who are specialized in the commercial code are charging in big transactions $3,000 and $4,000 an hour because it is so complex. But it is also, for 99% of the transactions that we will ever see, very, very easy to understand and find. And to Rick's comment about the comments, the commercial code was an original project of the Uniform Law Commission. It was begun in the 1940s. Back in those days, the Uniform Law Commission would meet annually. You would get to the annual meeting wherever it was, by train or by car. There was no interstate highway system. How did these uniform laws get written into bill form? Usually by exchange of mail, and then for a week every summer, it would meet in person. As the Uniform Law Commission was getting closer to completing the project, it realized that 3 commissioners from all the states, 48 states back then, wouldn't have the person power to get it through legislative enactments. So they brought in the American Law Institute, a bigger organization, also a volunteer organization of lawyers, judges, law professors, to do some of the heavy lifting to get the work done. Over the years, the ALI and the ULC have formed a joint committee of the permanent editorial board for uniform law, for the Uniform Commercial Code. They put out white papers. They were the ones who originally flagged the electronic issue. Both organizations happened to be president of the Uniform Law Commission when we appointed our members to the drafting committee that actually put this together. ALI put down an equal number of people. They met extensively for over a 3-year period. They met mostly hybrid. It's part of this was during COVID. The members of the committee would meet in person. They would also be online, and we would have any particular meeting, maybe 300 people actively involved in getting this done. It's complicated for the complex transaction. It's really simple for the simple transaction. And it will improve the law in Vermont significantly.
I think to me, the amazing thing is many of us have been doing transactions electronically for years, and you never think about the law that might or might not be there. You just assume I do this, you do that. And I did have a shark motif jacket from Australia not show up. But it was a really cheap thing for my grandson. But you never assume that there isn't a law protecting you in that area. And that's, so it is important that it's there. Because people kind of assume it is. And
Without it, there would be chaos.
yeah,
So I don't really have any questions on the substance of this, and I support the consistency for all the reasons articulated, but I question, this might be more for Rick, but do you know if this new electronic currency platform intersects with a topic that came up last biennium, which I don't recall a resolution, but it had to do with how we assign sales tax, if at all, to those timeshare exchange platforms with points, so digital points in their own economies. Does any of this language open up new conversations in the states that are adopting it and
No,
addressing that?
shouldn't.
Okay. And then marijuana sales, is that at all, in fact, because I know with legalized states, that's not in this uniform
No,
code at
not
all
really.
either.
it's federally not legal.
Yeah. I didn't know that was like entwined in this somewhere. The new Trump administration revises it, but thank you.
But this is really the foundation of law.
It is the skeleton upon which all commercial transactions are built.
we've got a whole bunch of things coming up on cryptocurrency and kiosks again
Well,
this week.
they would be in parallel with this, but neither is dependent on the other.
We'll look to legal counsel to keep us on the straight and narrow on that. Any questions? Or, trust me, letting us go off on our own is indeed terrible. Always keep the lawyers close when you're dealing in an area that is new and vague, and make sure you know what you're doing. Okay, Senator Brock.
Anything controversial or contentious in the changes that appear?
Good question. The only subject that has been contentious until debunked was the issue of, does this bill require the federal government to use electronic money instead of paper money? The answer is no.
Not yet.
It would
And
be,
yet,
we could joke about, wouldn't it be nice if the states could overrule the federal government? But sometimes those issues get closer than you would like it to be.
and we do have a bill coming up on requiring the taking of the cash. I don't think it ever got here last year, went through economic development. So we're gonna be dealing with a couple of these issues in the next week or so.
Then that gives me the chance to say thank you to all of you for what you are doing.
Thank you for all the years of work.
Yeah,
Oh, but the pay has been overwhelming.
it's all been in Bitcoin, right?
Piles of it.
It's probably as overwhelming or less so than others. Okay, committee. Anyone that you would like to hear from on this, or I think we'll let it percolate. Maybe till we've heard all these other bills by the end of the week, and then we'll just vote this one out. I'm trying to clear the deck because hopefully by the end of this week, we should have the yield bill that's pretty cut and dry. I may hold on to it for a little while, just in case we need it as a vehicle at some point, or may not. But I know they're hoping by the end of this week to have an education funding bill out of the House, and that will be our focus. So I'm going to try and clear as many of these pretty technical, non-controversial kinds of bills out of here ASAP. We're going to be doing the DFR and 129. 129 is my bill, right? Which is the virtual currency kiosk. I put that in at the request of the industry. I'm going to take that up at the same time we kind of take up DFRs. Because last year remember we froze the kiosks. They were still trying to figure out how they wanted to regulate these things, and they weren't quite comfortable that there was enough protection in place. My intention is to meld them, and if they aren't meldable, then not to do 129. I'm just telling you my intention as the sponsor, but I'm not holding any kind of authorship in that one. But I thought I'd give it a platform. If we have no other discussion, unless Maria is on her way as we speak, we have a break for half an hour until we do have our draft. So we are in recess.